important issues in the area of rule of law that just developed in recent days, just this past week. One of them having to do with this major announcement by the Principal Deputy Associate Attorney General at the Department of Justice in Washington, D.C., and contemplates the payment of $101.9 million to settle that Baltimore Bridge collapse lawsuit. Now, how does this come about? Well, the fundamental notion here is that the suit by the Department of Justice, the lawsuit, was filed last month. And it laid out exactly what investigators had learned about that short and catastrophic journey by a ship there in Baltimore. A spokesman for the Grace Ocean Private Limited, which owns the Dolly ship, and Synergy Marine Private Limited, which operates the vessel, not providing a lot of information about it. So we're getting all this from the U.S. Department of Justice. But the owner and that operator of that container ship that slammed into the Francis Scott Key Bridge last March, you remember that well, killing 6 workers at the time, shutting down the Baltimore port for weeks and weeks, agreed just this past week to pay $101.9 million to settle this civil claim. This is not a criminal matter, a civil claim that's brought by the U.S. Department of Justice. And what does the department say upon the announcement about this just this past week? Here's what Ben Miser says. He says, nearly 7 months after one of the worst transportation disasters in recent memory, which claimed 6 lives and caused untold damage, we have reached, we being the Department of Justice, but basically the people of the United States of America, in vindication of what happened here, we've reached an important milestone, he said, with today's settlement. And again, the suit, which was filed not too long ago in September, Justice Department had laid out in great detail, very particular information here in this civil lawsuit, a civil federal lawsuit, what investigators had learned about the ship's catastrophic journey happening on March 26th. We all recall this well. News breaking coming out of Baltimore about the damage not only to the Francis Scott Key Bridge, but about the commercial impact upon Baltimore, the port of Baltimore, for weeks since that time. Describing in this lawsuit can only be described as a cascade of failures on board, multiple points of entry, multiple points of problem here, according to which the disaster could have been avoided because of some poor maintenance or jury-rigged fixes. Again, all this coming out of the complaint of just a couple of months ago, some jury-rigged fixes to serious problems on the ship. None of the means available to help control the Dolly, that's the name of the ship, her propeller, her rudder, her anchor, her something called the bow thruster, none of those, according to the Department of Justice, worked when they were needed to avert or even mitigate the disaster. That's all in the civil complaint filed in this major piece of litigation coming out of the East Coast. Instead, as we know, not only from news reports, but now, according to this investigation, according to the results of the civil lawsuit now settled just before dawn, we recall this well, the Dolly, bound for Sri Lanka, lost power. The lights go out. Remember this well? It pulls into the port. It regains power and then lost power once again. And what does it do right after that? Again, according to the complaint, it strikes the bridge. The bridge collapses and plunges into water. And then, of course, that's when 6 people who are working on the bridge at that time are killed. The ship and the fallen bridge, again, in the port of Baltimore there into the cold and icy waters there, blocked the channel, severed a transportation artery, as we all know well, basically bringing maritime business at this one of the busiest ports to a complete halt. And in the wake of that, the investigation done, again, this is a civil matter, other things still pending out there, which we'll talk about. The Justice Department suit premised upon those basic findings. It arises from the company's effort to restrict, to condition their liability to $44 million. Where does that come from? Well, under federal law, ship owners can in fact cap or limit their legal responsibility if they can prove that they did not know, had no knowledge of serious problems with a vessel beforehand. And so if the government can prove that in fact that knowledge existed, if it was indeed there, the government can get a court to increase that exposure amount. And indeed, that's exactly what happened here. It is significant that the settlement, which was announced again just this past week, will cover the costs that the federal government, your government, the United States of America, bore in responding to this horrific disaster, including the loss of life, which of course is at the top of the list in terms of the human disaster here, but also all of the commercial and practical and construction related issues that come as a result of this disastrous event. It is far, however, from the final litigation resolution, all this. Many other claims out there. A separate criminal investigation is still going on by the Justice Department. That's a criminal matter to determine if these kinds of things that are the result of the civil investigation, should those also form the basis of a separate and discrete criminal prosecution of individuals, could also prosecute the company. You can do that as well in the federal system. Should a criminal investigation be pursued as well? In September, you may recall some federal agents boarded a container ship that was in the Baltimore harbor that was also managed by one of the companies that's settling this case. Their name is Synergy. And the authorities, of course, have not told us what that's all about. But plainly, that investigation, the criminal investigation going on by the Department of Justice, even as the civil case is now resolved. What else is pending out there? The state of Maryland, responsible for rebuilding the bridge, has also sued the companies civilly. The new bridge, expected to take about 4 years to build, cost almost $2 billion with a B, $2 billion altogether. State of Maryland, responsible for rebuilding the bridge, again, seeking that recovery of those monies. The families of the three men who were killed in September maintain as well that they announced in September, rather, that they were suing as well. Construction firm that employed the men also filed a lawsuit. Several other companies that also depend on port traffic, likewise claiming damages as a result in the compromise of commerce coming in and out of that. And yes, indeed, the city of Baltimore has also filed a lawsuit against Synergy and Grace Ocean. Same kind of thing going on. As we continue our discussion, we're going to our weekend broadcast, talking about two decidedly non-political issues, two significant rule of law things that happened in America just this past week, including this major decision to settle a lawsuit for $101.9 million against those companies that are responsible for that catastrophic Baltimore bridge collapse back in March, taking the lives of 6 people, shutting down the port of Baltimore for weeks. We know as well, as a result of the investigation and that civil lawsuit, the ship was carrying about 4,700 containers, 1.5 million gallons of fuel and lubricant oil, 21-person crew on board. And again, the greatest tragedy, of course, 6 workers killed, shutting down the port. Beyond that, 3 of the families of those workers suing as well, along with various other governmental entities pursuing criminal and civil remedies against the companies. Those include Grace Ocean Private, the Dolly ship itself, Synergy and Marine Private Limited, all kinds of entities out there collectively responsible for this. 21-person crew on board. Most of them were citizens of India. One crew member there sustained minor injuries in the crash as well. Again, why is all of this important? Why is this a rule of law issue? It illustrates, especially in the midst of our election season, why the Department of Justice does what it does. This is the kind of thing, this is a civil disposition, not criminal, but the kind of thing that your Department of Justice, responsive to you, serving you, should be doing on a regular basis. My own experience of 30 years working with the Department of Justice, you've got committed civil servants. Yes, you've got political appointees as well, responsible for the oversight of the civil division, of these various other entities inside the Department of Justice. They're doing this to advance the rule of law. They're doing this to promote justice and good things, even in the wake of absolute, abject human tragedy of this sort, loss of life, loss of commercial opportunities, and physical destruction, which again is the focus of continuing work. That's the role of the Department of Justice, and that's why it's so important that there be an attorney general, and yes, others, including a deputy attorney general, an associate attorney general, a deputy attorney general and his or her staff, all of those people, assistant attorneys general across the board in many different areas, who know what they're doing, who are experts, who have background and insight and perspective, and bring to this on your behalf good work, important work that is important to furthering the interests of our nation, and most importantly, its citizens. That's what's going on here. Yes, money does not by any means remedy everything. It is an imperfect and incomplete resolution, but it does begin to pay for some of the costs that we have incurred, that you have incurred as a result of the negligence. Arguably, we'll see if this happens, the criminal behavior of people responsible for this Dolly ship disaster. It responds to that particular need and interest to restore not only the coffers, but ensuring that places like Baltimore, other places around our nation, are protected from this kind of negligence, and again, arguably from criminal conduct as well. It underscores once again the importance of having a president who appoints an attorney general, who appoints a deputy attorney general, other assistant attorneys general, many other folks out there, United States attorneys, many other civil servants not subject to the political whims of a president. All of those people charged with responsibility for enforcing the law as they're doing here on your behalf. That's why this election is also much related to this particular article and this particular event happening in America just this past week. As you read about it, understand that it is more than simply a settlement, and we will continue to monitor and report on what happens in the wake of that. That's coming out of Baltimore. That's coming out of Washington, D.C., as you well know. We go then to the other side of our nation, to California, to the West Coast, and in particular to Los Angeles. Another article much in the news out there, which you can read about. You probably have seen in recent times, weeks, months, even years, a lot of focus recently upon Lyle and Eric Menendez. You recall well that they brutally killed their parents in 1989. You recall well, those murders grabbed the attention of all of us at that time. Lurid nature, a wealthy background in which all of these things were committed. And the brothers then initially denied any involvement in the brutal murder of their parents, eventually admitted that indeed they had done this. And their defense, both in the public domain and initially in a first lawsuit, a criminal prosecution of them for first-degree murder of their parents, was that they had been sexually molested, sexually abused by their father, also with the knowledge of their mother. Let's talk about exactly what has happened here. In the wake of their conviction after a second trial, Eric and Lyle Menendez have been in a state prison, now outside of San Diego, for about 30 years since their conviction by a jury in 1994. And again, it's during that period of time that an awful lot of attention is focused upon this event. This is a time, it was kind of a forerunner, if you will, the 1995 murder trial of O.J. Simpson, which also happens in Los Angeles County, also the focus of a lot of attention. This was in 1994. The murders again happening in 1989. A lot of attention given this before and continued since that time. Recently, an awful lot of Netflix programs, some informational documentaries about the Menendez brothers, what happened there, what didn't happen there, focusing in principal part upon not only the horrific events, but also their continuing position, which receives increasing support, that the reason, the motive for their doing this was the horrific sexual abuse to which they were subjected, principally at the hands of their father. Let's talk more about exactly what happened back then when they were charged ultimately with first-degree murder of both of their parents. During the first trial in the early 1990s, it was televised. We could watch this on TV. The brothers did, in fact, maintain that they had been sexually molested by their mother, feared for their lives, provided some fairly compelling testimony about all of that, but also said that their claims, their allegations of sexual molestation ultimately reached such a height that the only way to defend themselves was to kill their parents. Now, an awful lot of people at the time and to this day continue to say that that is not a proper defense. But in their first trial, that defense was raised, not without skepticism, not without pushback from the prosecution, but that was their position, advanced as it can be advanced by their defense counsel. As we often say on this broadcast, defendants have an absolute right to present those factual and, yes, indeed, legal defenses that they have. And so the Menendez brothers, through their counsel at that time in a first trial, presented this defense of sexual molestation in defense of the charges against them for the murders, the brutal murders by shotguns of their parents. And what happens is that in the wake of that first trial, there are actually two juries that are hearing the evidence there. In the wake of those two jury reviews of the evidence in court, the juries reach no verdict. They are hung juries, and the judge basically has to declare a mistrial. And so what happens is that in the second trial that happens then a couple of years later, prosecutors once again portraying the brothers as unrepentant killers, murdered their parents with shotguns to get at their family's assets. This was also part of the first trial, but also the second trial. The assets of the Menendez brothers, if you will, the sons at that time, they were 18 and 21 at the time of these murders. What happens is that they go on a spending spree after their mother and their father are murdered. And that includes buying a Porsche, buying a Rolex watch, buying a restaurant in Princeton, New Jersey. An awful lot of indication that there's not only no remorse, but frankly, they deny initially that they engaged in any criminal conduct, denied that they killed their parents. Eventually, they do in fact say that, yes, indeed, they committed this horrific crime, but again, raised this issue of sexual abuse by Jose Menendez, their father, and also with the knowledge of their mother, Kitty Menendez, claiming that she knew all about it. They said that they killed their parents because they feared for their lives. And when they confronted their parents about the abuse, They were worried that their parents would kill them to prevent the family's secrets from becoming public. All of that in the public domain and as a part of the first trial. In the second trial, none of that comes in. The judge says, I don't want to hear anything about the sexual abuse. I don't want to hear about that particular defense that you raised in that first trial that resulted in a mistrial. And so the case goes ahead, and that basically the third jury, there were two juries hearing the case the first time around, but in the second trial, what happens is that the jury comes back and finds them guilty, of these horrific crimes, first-degree murder. And in the wake of that, again, they are sentenced to life in prison without the possibility of parole. That's the sentence that is imposed based upon that second adjudication of guilt there in the Los Angeles County Courthouse. What happens in the interim? Well, they continue to serve their time. And along the way, it is significant. It is significant that in their time as prisoners there in the custody of the Los Angeles authorities there, the brothers go to work in prison as hospice aides to sick inmates. They're running an Alcoholics Anonymous program, some meetings there, meditation groups for inmates. They are completing college courses. They're supporting academics for themselves and other people. Letters provided from corrections officers in favor of resentencing and the release of the brothers. And then, in addition to that, all that going on while they're incarcerated for, yes, indeed, since 1994, 30 years in custody. Also, this public reattention to this issue of sexual abuse, and the thought that the sensitivity, the sensibility that we may have had in 1994 is not as compelling and understanding as is today in 2024. The notion today, we understand that both males and females can, in fact, be the victims of sexual abuse by parents and other people. And the fact that in the second trial, that defense was not permitted prompts an awful lot of people, including some celebrities, to say, you know what, we need to revisit this and think again about whether the sentence was imposed properly, whether there should be some attempt at remedial justice here. And indeed, that is the event that happens just this past week in a courtroom in America, in Los Angeles. The Los Angeles District Attorney, his name is George Gascon, Gascon. He announces that he is going to seek a resentencing of Lyle and Eric Menendez to do what? Basically, to reduce their sentence to such a place at which a parole board, if indeed the court embraces that, a parole board could then appropriately consider their release. They're currently serving these life sentences without parole. What has to happen here is that they would be sentenced to 50 years to life with the possibility then of parole. Again, if the presiding judge agrees with all of this, that term would be longer still than what the brothers have already served. But under California law, they would be eligible for parole immediately under state law because they committed these crimes when they were younger than 26. That's a lot to consume, I know. It's based upon their age, based upon the specifics of California law, that again, with this petition now by the Attorney General, by the District Attorney, rather, there in the state in Los Angeles, by this law enforcement officer, if a judge, again, reviewing that, agrees and decides to reduce their sentence, then it goes to the parole board. And at that time, again, not only would the district attorney, plainly the Menendez brothers, most members of their family, not all, but most members of their family, also advocating for a reduction in sentence. And the parole board would then have the opportunity to release them from prison. All of that is in the future. But the important news, again, of just this past week, that an attempt by a prosecutor to remedy the past and to address what was done in the past in a way that we probably would not do it today. If this case were going to trial today, as brutal and as horrific as those murders are, no one forgives that. No one looks at that and says, yes, indeed, complete exoneration. We know that they committed this murder. They have spent 30 years in prison as a result of that. At the same time, some questions about their trial. And as we come back here in Amicus Alarva, we will talk more about the implications of what happened in Los Angeles, and also for Lyle and Eric Menendez, and for all of us concerned about justice in the United States of America. This is Amicus, a law review. My name is Jim Santelle. We are talking in this, our first hour of our weekend broadcast, all about two stories, two articles in the news out there, lots of coverage of both. This major settlement involving the Baltimore Bridge collapse coming out of the Department of Justice, $100 million being paid by the ship owners and other responsible companies there to begin to remedy some of the problems there, negligence, arguably criminal involvement there, and also, speaking of criminal engagement and criminal issues, now talking about this decision by the district attorney in Los Angeles to seek what is basically going to turn out to be the immediate release of Lyle and Eric Menendez 30 years after spending that time in Los Angeles, actually in San Diego venued prison. Los Angeles County District Attorney petitioning the court, the presiding judge, just this past week for a reduction in sentence, the effect of which under California law would be to reduce the sentence imposed initially to the possibility of parole. And because of the specifics of the parole statutes and rules there in Los Angeles and California, would permit Lyle and Eric to be released by a parole board because at the time of their commission of these admittedly horrific offenses, brutally killing their parents, they were younger than 26, could result, if all of that falls into place, in their release. Again, all of that coming not only in the wake of lots of information about their work, their support of others, their development of programs inside the California prison in the time that they have been incarcerated there, but also a renewed attention. Some Netflix programs, some other informational documentaries about them, some interviews that they have given, giving increased attention to this issue of sexual abuse and sexual assault by their parents, and the fact that they were not permitted in the trial that resulted in their conviction way back 30 or more years, not permitted to advance that defense, attempting now some remedy under a system of justice that should in fact take that into account. Today, if this case were to go to trial, certainly that would be permitted. There would certainly be pretrial motions about that, and the scope of it, the dimensions of it would probably be the subjects of lots of pretrial arguments and motions and practice by the attorneys, both prosecutors and defense. But we understand today that there are legitimate defenses based upon these kinds of things, including sexual abuse, which apparently was fairly well established, not only in that first trial, but also since that time. We know that the father of these two, at that time, young men, probably did engage in that conduct. And the result of that was a sense among them, among the two of them, between the two of them, that this was their only remedy. Now, again, a jury may or may not buy into that theory, but that's the opportunity that defendants and defense counsel should have to present that, and denied that opportunity in that second trial. That's what the attempt is, to remedy the injustice done at the time. And so some important instruction coming out of this story, this event in Los Angeles. To this day, they're still incarcerated. It may well be days, could be weeks, maybe even months before they are released, but probably on a path to their release into the public domain, not only based upon the things they have done once again in prison, but also based upon a renewed sense that some injustice accomplished 30 or more years ago. And that too is why it is important in this case to elect a district attorney. District attorneys around the country typically elected to their offices. This particular DA is involved right now in a contest for his job, and certainly some allegations that he's doing this right now because of the campaign. But putting aside the important merits of that campaign, whoever the people of Los Angeles elect as their DA, significant to invest in that person and to ensure that they have the judgment, the perspective, the insight, the experience to know and to understand when actions of this sort are warranted and when they are not, to be able to confer with law enforcement, to be able to confer with police officers who know about the case, to look into evidence of what these particular prisoners have been doing while they have been incarcerated, to judge the merits, to engage with the family members, to engage with the defense counsel and the defendants themselves, to figure out whether or not there have been injustices in the past and also in the present. That's what a good district attorney does, absent politics, absent partisan perspective. And that's the reason why this story, aside from its great significance for the Menendez brothers and the larger family, aside from the significance of that, is also like the Baltimore Bridge collapse lawsuit and the settlement there. It is important instruction just this past week about what the institutions of justice can and should do. It takes courts to do this, right? It takes litigators in the civil case. It takes prosecutors and defense counsel in a criminal case. Everybody has to do their part. Nobody should be compelled to do something that is not within their own sense of good judgment. But when it all comes together, even inside the adversarial system, as there was here, as there was in the Baltimore case, even inside that system that depends upon that adversarial presentation to result in justice, to find the facts, to determine exactly what happened, what didn't happen, the result in our system is approaching a greater sense of justice. Imperfect, absolutely. Needing remedy on a regular basis, as this shows, absolutely. But also, once again, underscoring the importance of having people in these positions, the importance of voting coming up here in the very near future, 10 days from now, not only for a president who again appoints an attorney general and U.S. attorneys around the country, but also in many other places around our nation, state, local, county elections, where there are law enforcement folks, sheriffs, police officers, police chiefs, and district attorneys who are elected to those officers. They obviously appoint police officers, all of that underscoring the importance of voting when it comes to a criminal justice system that we all can appreciate and embrace and understand here in America. As we continue here in our second hour, more focus upon politics and partisan politics as we talk about consequences of the upcoming election
Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Jim Santelle, and yes, indeed, this is the second hour of our weekend broadcast, talking about all things government-related, court-related, rule of justice-related, administration of justice inside our courts and outside our courts as well. Rule of law, an important topic, an important commission for all of us, especially as we go into these final days before the election coming up in 10 days from now, not only of a president, but plainly also of senators and congressmen at the federal level. Many, many other positions up for election in our counties, our cities, our villages, our towns across America, including an awful lot of law enforcement positions and authorities. The importance of understanding voting, not only with respect to those big ticket items that are on the ballots as we go forward and anticipate, if we haven't already voted in early voting on November 5th, not just for those big ticket items at the top of the ballot, but also understanding that law enforcement and the rule of law also on the ballot, as partisan folks often say. It is also on the ballot because the very people you elect to positions like attorney general, like district attorney, like sheriffs, like police chiefs, those kinds of things, if indeed in the particular jurisdiction those are elected as opposed to appointed, all of those kinds of things have an impact upon your lives, the ways in which your communities are safe and secure or not, and the kinds of things that we should anticipate from government, expect from government when it comes to reasonable, rational, and balanced, apolitical, nonpartisan law enforcement. That issue, those issues too, very much on the docket, very much on the ballot as we anticipate the election of November of 2024. And so as we think about that, we're also mindful of the fact that the present polls at the top of that ballot, at the top of the list, right now show the two principal candidates, the Democratic candidate Harris, the Republican candidate Trump, virtually tied in the polls. And with respect to those 7 states, Wisconsin being among them, also razor-thin changes, razor-thin separations of their support in each one of those states. An awful lot of people saying if anybody tells you today that they know for certain how this election is going to go in 10 days, once all the ballots are counted, don't believe them, because nobody knows. Nobody knows. And it is in that context that, based upon some of your previous comments and questions sent to me here in Amicus, a law review on the broadcast stations of Civic Media, that we talk in this weekend broadcast about two issues, again, that you brought to my attention. One of them is what happens if the polls are right, and somehow, as we do the calculation under the Electoral College, if both Harris and Trump tie in the Electoral College at 269 votes each, neither one of them reaching the requisite 270. What happens? What does the law say? What does the Constitution say about that? Is there some historical precedent for that? The answer is yes, way back in 1824. We're going to talk about that. And then the other issue that many of you have also articulated some concern about, as we should all be, and that is these statements by Donald Trump, the Republican candidate for the presidency, that if he wins, he is going to be using the Department of Justice, for which he has complete immunity now in the wake of the Supreme Court's decision of July 1. He's going to be using the Department of Justice to jail his rivals, as he has said, and do other things that are contrary not only to the purposes and missions and methods of the Department of Justice, but that also would tend and would accomplish an usurpation of the basic principles by which the Department of Justice has been working on your behalf. We're going to talk about both of those issues. And then also at the end of this, our second hour, some focus upon a group at the center of some of Donald Trump's planning for a second term that you probably haven't heard of. And they're the American First Policy Institute. Among other things, the connection to the rule of law, of course, is that they are advocating for and articulating some of these same principles inside of the policies, the practices inside the Trump campaign, outside the Trump campaign, that have an impact upon the Department of Justice and the way that it does its work. So let us begin. Let us begin first with this question of what happens if Harris and Trump tie in the Electoral College. Well, let's begin with some fundamentals. We know a lot of this before we get into some of the math here and some of the constitutional principles. In the United States, we elect our president and vice president not according to a popular vote. An awful lot of advocacy out there, as you well know, to get rid of the Electoral College. How do you do that? You need a constitutional amendment. How do you do that? Both houses of Congress have got to pass a constitutional amendment. You've got to have the states doing all that. That's also prescribed by the Constitution. That's a big lift. And until that happens, we do not elect presidents by popular vote. We do it by this thing called the Electoral College. To win, and here's the important math, a party's ticket must win the most votes in enough states to attain an outright majority of those electoral votes. And right now, that number, that magic number, we're going to be hearing a lot about that in the next 10 days. We've already heard a lot about it. Certainly on election night, we'll hear a lot about this. 270 votes, that's the number, out of a total of 538 up for grabs. Now, lurking in that overall figure is the possibility, the potential, and let's say it right up front. The potential for a true tie is low. It's minimal, but it could happen. A potential that no candidate wins a majority, that both of them reach 269 votes, Electoral College votes, seemingly not in play in 2024. An awful lot of people say it's unlikely, and it is unlikely that will happen. But nonetheless, if in fact there is a tie at 269, we could run into a situation where there is not a decisive winner. And what happens? What happens in the wake of that? Well, let's talk first about some of the scenarios that could reach that 269 plausible, but again, unlikely scenario coming up in just about 10 days or so. Key swing states in ways that would have an implication for that. Again, anything can happen. The voting has begun already, but not yet counted. We don't know for certain, but of the small number of scenarios in some of the forecasts going on right now in which Harris and Trump tie, four of them are perhaps the most plausible. And those are the ones that, again, in this unlikely scenario, each of them would capture states and congressional districts that would tie them. Harris would come up with 225 electoral votes under one of these scenarios. Trump would capture 219. And that would be the base. Those are the states that are presumed up to now to be secure. 225 for Kamala Harris, 219 for Donald Trump. And so that leaves those 7 other states. We know what they are: Arizona, Georgia, Michigan, Nevada, Pennsylvania, North Carolina, and yes, right here in Wisconsin. Those are the so-called 7 principal battleground states. Again, we talk a lot about them on a routine basis. Got a number of scenarios, and let's talk about them briefly, and then we'll talk about what the implications would be if there is this tie. Again, one of them involves Trump holding on to North Carolina, flipping Pennsylvania and Michigan. Harris retains Wisconsin, Arizona, Georgia, Nevada. And as a result of that sort of combination, you would reach 269. The next possibility, the scenario 2, if you will, includes mostly the same results, but Kamala Harris and Trump would trade Georgia and North Carolina's identical electoral votes and reach the same 269 stalemate. Scenario 3, for example. Again, all of this somewhat, if not completely unlikely, but nonetheless, Trump reclaims the Sun Belt states, highly unlikely, and that Nebraska 2nd District. There's been a lot of focus on that as well, while Kamala Harris holds on to the 3 northern battleground states, including right here in Wisconsin. Scenario 4, again, the least likely among these already unlikely scenarios, involves Trump carrying all the northern battleground states in Nevada, while Harris wins the 3 southern swing states. And again, I suspect that many of you are rightly saying, well, those kinds of things won't happen. Again, all of those are simply possibilities as we go forward and think about what could happen here. None of this completely anticipated, but could reach the result where both of them get 269 votes. We also have this situation where, of course, we've got electors. One of the things that we saw in 2016 is that 5 Democratic electors, 2 Republican electors, remember this, did not cast their votes for their party tickets, but instead voted for other candidates That was back in 2016. This also assumes, of course, that all of these electors coming out of these states will be faithful to the results from their states. If you get what's called a faithless elector, that could change this dynamic as well. And the reason why all that is important is because we then turn to what? We turn to the United States Congress. 269 coming out of November 5th and maybe the days right after that. If the Congress finds an absence of a majority when it meets on January 6th of 2025, that's the date for the official counting of those electoral votes. And if at that time, those envelopes, which we now know an awful lot about, if they're opened and the certification is that the Electoral College is a tie, 269, what happens? Well, we've got an answer to that. It turns out that the 12th Amendment to the Constitution, it is in our Constitution. And now we talk in this rule of law discussion about what that means, what it says. There are provisions for both the House and the United States Senate to make this decision. And we think then about what will happen here. The 12th Amendment calls for the House of Representatives to immediately, that's the word, choose the president from no more than the three candidates who won the most electoral votes. That's what the 12th Amendment says. In a 269 tie, that would mean that just the two major party nominees would be in play. Although, again, a faithless elector scenario could somehow affect that result, but unlikely once again, as all of this is to some extent. But the choice is not under our Constitution based merely on a simple vote of the House of Representatives and its members. You know well, the House is populated by what number of people? 435 representatives that we are electing again on November 5th. And it will be the new House, the House that's elected on November 5th, sworn in early January of 2025, that will then do this 12th Amendment review and analysis. It is decided not by members as a whole, not that everyone has a singular vote, and we figure out based upon that 435 division, again, right now, a very narrow majority for the Republicans. That's not how it's done under our Constitution. Instead, according to our 12th if both of the principal candidates for the presidency, Kamala Harris and Donald Trump, if neither one of them reaches the requisite number of 270 electoral votes, both of them tie at 269. Highly unlikely that will happen, but possibility. Number of different scenarios out there that we talked about in our previous segment that raise the possibility if there's no decision based upon a clear winner, 270 votes, 269, 269. What does the 12th Amendment say? Well, with respect to the presidency, it is the House of Representatives then that would select a president of the United States of America. 435 members there. But significantly, the 12th Amendment does not contemplate simply a popular vote among them. Instead, the decision is made through a system whereby each state delegation casts one vote according to the preferences of each member inside that state's delegation. In other words, all the delegations get together individually. They choose among themselves, again, based upon partisan views and perspectives and allegiances there. And the states themselves vote as delegations inside the House of Representatives. And it may well be that if there are delegations where the Republicans and Democrats are split in congressional districts there, the delegation cannot reach a result, cannot reach a decision. Those delegations would be unable to cast a vote unless one member breaks with the party and votes for the other one. To win, a candidate, again, must win a majority of state delegations, and that number is 26. A second number here to keep in mind. You need 26 state delegations right now to win the presidency. Not a majority of the 435, but 26 delegations. Again, voting by delegation. And currently, of course, as all of you can figure, regardless of your political focus and allegiance, currently right now, Republicans hold a majority of the House. In 26 of those states, 26 of those state delegations compared to 22 of the Democrats' delegations. Now, that can change, of course, based upon things that will happen again on January 5th. If anything, right now, an awful lot of people anticipate that the Republicans may control as many as 28 state delegations inside the House of Representatives. Democrats may drop to 18. That's not to say that the numbers overall would change hugely, but again, anticipating a continued Republican ownership and majority in the House could be as high as 28 delegations for the Republicans, maybe as low as 18. Even if it doesn't change at all right now, the calculus is 26 delegations in the House are Republican, 22 are the Democrats. And if, once again, those delegations vote as they predict, those delegations then select the next president, and likely under that scenario, which again, lots of things have to happen here before any of this comes to pass, but under the 12th Amendment, those delegations vote, and if they vote right down party lines, Donald Trump is elected our next president because of the number of delegations inside the House of Representatives right now are majority Republican as opposed to Democrat. Again, all this premised upon a tie, 269, and then review by the House of Representatives. Fascinating stuff going on here right under the 12th Amendment. Is there precedent under this? Well, a little bit. There's one precedent for a contingent election in 1824. 1824 was the last time that we looked at some of this. At that time, there was a party called the Democratic Republicans. They were known then as the Republicans, but they're unrelated to today's party. And they held a fairly dominant political position at the time. And that was in the midst of something called the Federalist Party's decline at the time. There were four separate Democratic Republicans who contested the presidential race at the time. And the number at that time that he had to get under the Electoral College was 131. 131 was the number out of 261, all right? But every contender fell short of that mark. Again, nobody reached that magic number of 261. Andrew Jackson won 99 electoral votes. Secretary of State John Quincy Adams, 84 electoral votes. Secretary of State William Crawford, 41 electoral votes. And House Speaker Henry Clay, remember him from history, came in fourth with 37. Nobody gets a majority coming out of the Electoral College. And when the House gathered in February of 1825 to choose a president again under the Constitution, it could only consider Jackson and Adams and Crawford. Those are the top three recipients of electoral votes under our constitutional regime. All were Democratic Republicans, and the party had internal divisions about how we go on this, and so eventually split into a new party system by the 1828 election, and that was history that resulted ultimately in Andrew Jackson's election, defeating Adams again in a head-to-head rematch 1828. But in 1824, 4 years before that, House members from the states that had supported Clay mostly shifted to Adams' camp when Clay decided to throw his support to Adams. And that enabled Adams to win the 13 additional states that he needed to attain the presidency. And the 12th Amendment came into play, and John Quincy Adams became the president over Andrew Jackson and the others. Jackson, again, 4 years later, goes on to win the presidency on an out-and-out vote, but it happened once before, 1824, when there was not a clear victor under the Electoral College. Again, fascinating to think about what may happen here. House of Representatives selecting our next president, if indeed there is a tie between Donald Trump and Kamala Harris. What about the vice president? Where do we get a vice president if indeed the same happens there, a tie, 269, 269 again? The Constitution gives us instruction on this. And we know, of course, the vice president is an important player in all of this, unlike the president when it comes to selecting a next president, because the vice president is also what? The vice president is the president of the Senate. We know that well because Kamala Harris and before her, Mike Pence running up to the Hill on a regular basis to break log jams when it comes to legislative votes happening in the Senate. It is the Senate under our Constitution that decides who fills the key position of the vice presidency if neither candidate, neither J.D. Vance nor Tim Walz, gets a majority in the Electoral College. If they also split 269 to 269, it is the House there. It is the Senate, unlike the House, that then makes the decision. And when we talk further, we'll talk about the possibilities inside a Senate vote with respect to the selection of a vice president under our Constitution as Amicus, a law review, continues. This is Jim Santelle, your host of Amicus, a Law Review, as we continue to talk about the election and something that's fairly remote, unlikely to happen, but the possibility, given the closeness right now of the race between Donald Trump and Kamala Harris for the presidency, razor-thin leads, if any at all, in the 7 so-called swing states, and even around the country. Very, very close race. No one predicting with absolute clarity or certainty exactly what's going to happen here. Always the case until we collect and count all the votes, but especially in this election, an awful lot of predictions about how close this will be. If, in fact, it is as close as it can possibly be, some scenarios for both of the principal candidates to get not the requisite number of electoral votes, which is 270, but 269. And in that instance, in that unlikely but plausible possible circumstance, the presidency elected and selected by the House of Representatives based upon the number of delegations there. Almost certainly, if indeed it goes to the House as it did in 1824, almost certainly here, a Republican choice to place Donald Trump in the White House. And then what happens with respect to the vice presidency? Well, the 12th Amendment, again, divides this up, even though it's a unified ticket now. We go to the Senate to figure out who the vice president should be. And there, unlike the House, it's not based upon delegations, where, of course, you've got 2 senators from each state. There, unlike the House, a Senate contingent election vote would be based on a vote of the chamber as a whole. And by that, I mean in which each candidate needs 51 of 100 votes to win. It's a simple majority, 51 out of 100. And of course, we know right now that the Democrats hold a very, very narrow lead, 51 to 49 majority in the Senate. But the significance, of course, is all things can happen. Again, it's the new Senate that would select a vice president. We know that there are some very tight races in West Virginia, for example. We know that John Tester there in Montana is also facing a strong contest. You've got Sherrod Brown in Ohio. You've got other Democrats who are also defending their positions, including in Arizona and Michigan, Nevada, Pennsylvania, and yes, certainly right here in Wisconsin. All of those various results, and some of them closer than others. But again, depending upon what happens on November 5th and the days following, you could get a further change in the math and the composition of the United States Senate. Right now, Democrats 51 to 49. And that is significant, of course, because if the Senate remains exactly as it is, and everyone votes according to their political party, there are actually 4 independents inside the Senate. They tend to caucus with the Democrats. And so if you add their numbers in, then you might get the selection of a Democratic candidate for the vice presidency. That, of course, would be Tim Walz. An interesting result if indeed you elect a vice president in the Democratic ticket and the House elects a Republican candidate. Unlikely, once again, something like that would happen. But once again, it is dependent upon a vote inside the United States Senate. Contingent election based upon who gets 51 or more votes in the United States Senate. An awful lot of that, of course, depending upon who we send to the United States Senate across the country in this coming election. As we know, a lot of those seats are contested. So once again, all of these things a part of our Constitution. And that being said, of course, there are the possibilities of some unexpected delays in the House's process. If the House fails, for example, to elect a president, if for some reason that doesn't happen by Inauguration Day, which is January 20th of 2025, the Senate's choice for vice president would serve as an acting president until the House elects a president. Fascinating, right? And if the Senate also fails to elect a vice president, according to its constitutional mandate, the Presidential Succession Act, this is legislation, calls for the Speaker of the House to be next in line to serve as an acting president. And assuming that individual, of course, right now it's Mike Johnson, meets the presidential eligibility requirements and that the House is able to select one, that hasn't easily happened in recent times, of course, but all of those things contingent upon many, many possibilities, all of that quite unlikely. But nonetheless, that's what our Constitution says. We've got selection by the House of the president. We've got selection by the Senate of the vice president, if indeed the Electoral College does not produce a clear winner. 270 is that magic number we're all looking to. The 1824, 1825 example showing that this does, in fact, raise the possibility under our Constitution of a congressional decision about who our leadership is. Unlikely in this election, but a possibility, and the law is still there. The Constitution still requires that a decision is made in that way. Fascinating to think about. Again, something we wouldn't discuss absent, number one, your good questions and your good inquiries about what this 12th Amendment says, voiced here on Amicus, a Law Review, and also animating the other issue that we're going to talk about now in this, our final segments here on Amicus, a Law Review, and that is, what can Donald Trump do when it comes to the Department of Justice? We know once again that the United States Supreme Court has stunningly said, as of July 1, changing the Constitution, that a president is now completely immune from criminal prosecution, can't touch him or her for engagements with, communications with, things involving directives to the Attorney General and the United States Department of Justice. That longstanding understanding, including what happened with Richard Nixon, that indeed you can't suborn perjury, you can't obstruct justice, you can't do things with respect to the Department of Justice that are contrary to the law, that has been upended. And the Supreme Court now says that presidents get complete passes when it comes to engagements with the Department of Justice. It makes important Donald Trump's repeated statements in the public domain, not interpretations of what he has said, but out-and-out talks, out-and-out calls for retribution against his political rivals and others. He routinely calls for prosecuting his current opponent, that's Vice President Kamala Harris. He talks about prosecuting the current president, Joe Biden, and, of course, others in the cabinet. And he has charged the Biden administration with weaponizing the Justice Department against him. And he has said that when he becomes the president of the United States of America, these are his words, not mine, not an interpretation, he will similarly use the Department of Justice to jail rivals, to weaponize his Department of Justice in the same way that he feels, without justification, without factual predicate, but he feels the Justice Department has been weaponized against him. This is payback time, according to Donald Trump. And the question you have raised is whether he could do that kind of thing. What about the Department of Justice? What about its constitution, its structure, its analysis, the way that it functions? Can he, in fact, do those kinds of things? It raises questions about what kinds of restraints are there right now that could prevent him from following through. And since Watergate, of course, we know, the presidency of Richard Nixon, followed by the presidency of Gerald Ford, Richard Nixon resigned under threat of impeachment for meddling with an FBI investigation, for doing exactly what the Supreme Court has now said a president can do. American presidents have taken pains until July 1 and through today. Joe Biden is not exercising any of the authorities that the Supreme Court has given to him appropriately. He is not committing crimes in the office. He is not exercising duties and responsibilities beyond what the Constitution and the laws of this country say, but a future president could. And the question is, with that kind of an immunity grant, what about this traditional relationship between the White House and the Department of Justice? Talked about a lot in this broadcast, this arm's length notion that while the Attorney General is indeed a member of the cabinet, still, you do not want Republican administrations, Democratic administrations. You do not want a presidency, a White House that is directing the day-to-day activities of the Department of Justice. You want an independent, admittedly with a small I, an independent Department of Justice that can make determinations not based on politics or partisan views or even animus about political rivals, but based upon what? The facts and the law. That's what the Justice Department does. That's why it's so important to elect a president who appoints an attorney general, appoints U.S. attorneys who understand that nonpartisan, apolitical commission given to them. That's why this is all important. And that's why our tradition has been arm's length. Talked a lot about the fact that Janet Reno, with whom I had the great honor to work for about 2 years when she was our attorney general, did not get along with Bill Clinton and did many things that he did not like. And I would offer at the time and offer to this day that that kind of relationship is a good thing because it places them at arm's length from each other and ensures the integrity of a Department of Justice that is not directed by the whims and the political animus, if you will, of a president. And so that tradition which has lasted for the most part until the previous Trump administration, when we know that Donald Trump began to break down some of those barriers, directing his attorney general dismiss certain cases, for example, Michael Flynn, other things involving some of his allies of the president. We know that that began to fall apart. In a second term, Donald Trump has promised that those guardrails will come apart. And the question is whether that could happen. Let's talk about what the Department of Justice is all about. Plainly, if reelected, Donald Trump does have the prerogative to appoint an attorney general. And how does that process work? Well, he names that attorney general probably even after he is elected. And that can happen. The nominating process can go forward. And the review of a nominee could be considered by the Congress even before the new Congress takes office. They're the ones who are going to be deciding on it. But a lot of review and analysis in the public domain, that will be the subject of a lot of focus. Who is the president's cabinet between November and January? And Congress can begin to take some of that up, even though they vote on that. The advise and consent portion of our Constitution says presidents nominate and the Senate confirms. And that's why, once again, not only is the presidency at play, but also, as you know well, a third of the Senate. It makes a difference who we send to the Senate because, again, senators are the ones who conduct hearings with respect to all of the cabinet secretaries, including the attorney general herself or himself. And they can, in fact, and they have from time to time, as you know well, decide in their advise and consent capacity not to confirm a president. If the Republicans have a command of the Senate, likely they will confirm the attorney general, whoever that is that the president may select. If the Democrats have the command of the United States Senate, likely that they will at least give some pushback on that, depending upon who the candidate is. That advice and consent process is one of the guardrails that's out there in our Constitution that would prevent a president from placing in office, not just for the attorney general, but for all those other positions that I've talked about in this broadcast and others. The deputy attorney general, the second in command, the associate attorney general, responsible for many things involving civil litigation, including that case coming out of Baltimore and the ship there. The assistant attorneys general in all sorts of categories for environment and tax and criminal and civil and antitrust and national security, a great number of those, all of those also appointed by the president, identified by the president. And again, Donald Trump has indicated that he will make those appointments based upon loyalty to him. His words, not mine. And of course, all of them subject to confirmation by the Senate. That's the guardrail on that. But it would give him, again, assuming that those people that he nominates are confirmed by the Senate in one way or another, would give him control over a vast machinery of the criminal process and also the civil process inside the Department of Justice. One of those most important appointments, of course, and the authority inside the Department of Justice is the FBI director himself. Ordinarily serves a 10-year term. Right now, we know that Christopher Wray encumbers that position. But a president could, in fact, fire an FBI director. We know well that Donald Trump, during his first term, fired Wray's predecessor. His name is James Comey. He did that in 2017 and could nominate and could appoint a new FBI director. Again, not without advice and consent, but nonetheless has authority to establish inside the Department of Justice some greater authorities there. He also has, of course, the responsibility, the obligation to appoint 93 United States attorneys around the country, assistant attorneys general, all those kinds of people who enforce the federal law. And that includes criminal cases, civil cases, great authority and districts of things under the laws and structures there could prevent or also facilitate a decision by a president, including Donald Trump, to restructure not only how the Department of Justice works with respect to the independence from the White House, but also pursuing what he has promised to do, which is pursue his rivals. So we know indeed that the president has this huge appointment power. Attorney General, Deputy Attorney General, United States attorneys around the country, all of them have to be confirmed by the Senate, and that is a significant stopgap. That's a significant standard that also applies, and indeed a Senate could in fact decide not to confirm some of those nominees, maybe forcing some more moderate choices or some other people that are more amenable to what a majority of the senators would like to see in those positions. But there's also a limit to that, because Trump could also use the vacancies that would be created early in his term under some specific procedures that are also a part of this. Fascinating to think about this as well. He could use the vacancies to fill the department's top ranks without Senate confirmation for up to 300 days at the start of his administration. He would be limited in making these appointments to a pool of senior Justice Department employees and Senate confirmed officials. In other words, they've got to be in place already, have to be Senate confirmed. But for 300 days, he could identify and appoint them to some of these positions if indeed the United States Senate is balking and saying, no, we won't want to go along with your appointees. And those appointees for 300 days could change dramatically. This relationship between the department and the House and the White House itself, preventing some of these partisan things from being in place, the partisan directives that say that there should not be a connection between the White House, depending upon who the president would appoint and how that works, that could also affect criminal investigations. And this gets us back to the central question that some of you have raised, and that is that unfettered communication, whether it's under a 300-day period or a broader period of time. Under these circumstances, it depends upon who you put in all these positions, right? When it comes to the conduct of criminal investigations, what are the standards there? Well, again, as we've talked at great length in the past, one of those standards is facts and the law. Those are the two principal things that animate investigations. Everybody, civil servants, should be guided by that, and political appointees as well. That's the premise upon which our Department of Justice works. Interestingly, Donald Trump has also contemplated in that connection a complete overhaul, and he could issue an executive order removing civil servant protections so that the Attorney General could fire thousands of nonpartisan career lawyers and FBI agents. That is a stunning thing to think about. It is a part of what has been discussed out there in the public domain. And indeed, in the last hours and days of his administration, way back in 2021, he did in fact issue an order. It was known as Schedule F. It's also now a part of this thing called Project 2025. It's also a part of what has been advocated for by this other group that we will talk about briefly today called the America First Policy Institute. And they're advocating, again, the reinitiation, the resurrection of Schedule F, because when Joe Biden became president, he rescinded that. It never happened. But it's a blueprint for basically changing the way that civil servants work throughout the government, including in the United States Department of Justice. And so this combination between appointing people who may be loyal to you, getting Senate confirmation, or even not getting it for 300 days, changing the ways in which civil servants who are committed to doing things in nonpartisan ways, apolitically, the combination of all of those things provide some guardrails, some standards, but not a lot. Not a lot. And under the right circumstances, Donald Trump could, in fact, at least initiate, if he's got the right people who are loyal to him and who want to turn their back somewhat upon the commissions given to them to observe the law and the facts, could open investigations, or at least influence investigations of a criminal nature. And that gets us back to the allegation or the claim again that Donald Trump wants to pursue criminal investigations of his political rivals. The Trump-appointed Attorney General could tap someone in the criminal division, maybe a special counsel, maybe mainline civil servants loyal to the president to pursue those investigations And as is often said, the process could be the punishment, even if in the end those investigations do not result in an indictment by a criminal grand jury, which again, another standard, another stopgap on prosecutions of people for political purposes. And even if you do get U.S. attorneys out there, the process in many ways of simply initiating investigations that are without merit, if that is accomplished by Trump loyalists inside the Department of Justice, appointed by Donald Trump, maybe arguably confirmed by a United States Senate or not during a 300-day period, the prospect of investigations being initiated, even if they're not consummated, even if they're not brought to conclusion, that is concerning enough. And as I said, the process is often the punishment when it comes to investigations. That's the specter. And that's the reason why all of this is a source of great concern. Next time, we're going to talk more about other aspects of this, including the Inspector General, which also provides a stopgap. We're going to talk more about the pardon power that's out there and other restrictions on the limits of a president to use the Department of Justice, even in the wake of the decision by the Supreme Court to grant him great authorities. We will also continue and really initiate our discussion about this other entity out there that's advocating some of these same kinds of things. It's a group called the America First Policy Institute, with little fanfare and not quite as much scrutiny as Project 2025, advancing many of these same kinds of principles in a policy book called the America First Agenda. We're going to talk more about that. We're going to talk more about the consequences of a Trump presidency with respect to the Department of Justice, with respect to the rule of law, with respect to courts in America in our next iteration of Amicus, a law review. Join me for that next weekend as well. Have a good weekend, everybody.